Hello, everybody. Welcome back to Patriot's History. And we are in Chapter 4, A Nation of Law. By the way, hi to all those who attended the Arizona Homeschool Convention. That wraps up my convention touring for the year. It was so good to see so many people out there, particularly so many young people. I can't tell you, folks, how many young people I had come running up and say, "Oh, we got your book. We read your book." It's just amazing, but it shows you it can be done. And so thank you all very much. Of course, I'm reading through Patriot's History of the United States, which is now in its 40th printing, the book written by Michael Allen and myself. But every time we come to a document, I read through the document and comment and explain the document. So we're in the middle of the Constitution. This is going to take us a couple more sessions probably. But right now we are in Article 2, the Executive Branch, and we're going to start Section 2. Now, you can get any copy of the Constitution. I'm reading it from our Patriot's History Reader, which is a very good compendium of some of the best documents in our history. So take that for what it's worth. All right. Section 2, Presidential Powers. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states. When called into actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties. Now, this is a little controversial because many say that he's not required to obey the consent of the Senate, just that he can seek it, but isn't required to obey it. So I think that's a little gray area. Courts have ruled, of course, that no, he has to go by the consent of the Senate, but I think that may be looked at again, maybe in the future. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors or other public ministers and councils, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior offices as they think proper in the president alone, in the courts of law, or in the heads of departments. Now realize no departments have been named. Washington will later name a cabinet where we have a Department of War, a Department of Treasury, and Post Office. Later, we had a Department of the Navy, but such departments are not mentioned specifically in the Constitution. The president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of the next session. And as I mentioned last time, the Senate has been very twitty widow wabbits in always keeping one person in Washington so that the Senate never goes into actual recess to prevent Trump from ever nominating recess appointees while they were stalling his appointee. Now, with Biden, it doesn't matter, but with Trump, it did. Section 3. State of the Union convening Congress. He, president, shall from time to time give to Congress information of the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them at such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4, removal. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, as I mentioned to you last time, maybe it was 2 times ago, the impeachment process has been badly abused. I'm not saying they didn't get the right answer, the right result, but it hasn't been done the way it's supposed to be done. And the way it's supposed to be done is that the House says the president is indeed guilty of high crimes and misdemeanors. When it goes to the Senate, excuse me, the Senate, you'd think I was trying to sing like Michael Jackson there. When it goes to the Senate, all the Senate is supposed to do is to rule guilty or not guilty on the charges. According to the Constitution, the Senate has no authority to say these charges don't rise to the level of an impeachable offense. These charges aren't high crimes and misdemeanors. Excuse me. The House just said they were. And you have to go by what the House says. They don't. But constitutionally, you do. So, Andrew Johnson was acquitted. He violated the law. Wasn't a good law. In my view, it was a terrible law. In my view, he should have fought it through the courts. But he was a hardhead, right? He was going to do it his way. And so he just broke the law. Well, he was impeached on 11 articles. The Senate refused to convict him on the one all-inclusive Article 11, which took out the other 10, really on a very narrow vote. I think it was 1 vote. And really, because the senator said, well, this doesn't rise to the level of a high crime or misdemeanor. I'm sorry. I mean, that was the right result, but it wasn't the right way they got there. They abused the process to get that result. When Clinton was impeached, again, the Senate, largely with a bunch of Republicans, said, well, this doesn't rise to the level of high crimes and misdemeanors. Not your job. Read the Constitution. You aren't empowered to do that. You are only empowered to say, did he do it or did he not? And yes, he did. Clinton should have been impeached and should have been removed. Andrew Johnson should never have been impeached in the first place, but should have been removed. Now, Donald Trump should never have been impeached and was not removed. And in the first impeachment trial, there was nothing there, so there was really nothing for the Senate to say, well, there's no high crimes or misdemeanors. They correctly ruled in that case that he was not guilty of whatever they said he was guilty of. And same thing in the second impeachment, that he was not guilty of whatever they claimed he was guilty of. But the first 2 trials were wrongly done. The procedure was wrong, and they violated the Constitution. Okay. Article 3, the Judicial Branch, Section 1, Judicial Powers. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior court, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. In other words, as long as they behave themselves, you can't kick them off. Section 2, jurisdiction trial by jury. The judicial power shall extend to all cases in law and equity arising under the Constitution, laws of the United States, and treaties made, or which shall be made, under which their authority to all cases affecting ambassadors or other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies which the United States shall be a party to, controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or citizens thereof, a foreign state, citizens, or subjects. Well, what is it saying? It's saying that in most cases, the federal judiciary has authority, but there are many state cases, cases of one citizen against another or breaking the laws of an individual state, that the Supreme Court does not have authority over until we get to Marbury versus Madison, where Justice Marshall introduced the notion of judicial review. I'll get to this much later, but in essence, Marshall said, somebody's got to decide what the Constitution means, because there are going to be conflicts over what does it really mean. Somebody's got to decide it, and it's going to be the U.S. Supreme Court. Now, Madison said the same thing when he wrote the Constitution. He said to everybody who would listen, sooner or later, I think he said this in the Federalist Papers too, sooner or later, you're going to have conflicts over what laws mean and what the Constitution means. And someone will have to adjudicate that conflict. And he said, I see no other way than that it ends up with the Supreme Court. He didn't really like it. You could tell from his writing, he wasn't a fan, but he realized that, hey, you have to have a referee. Someplace there has to be somebody that can make the final call. You're safe, you're out, right? And so the Congress basically put that in the hands of the Supreme Court when it put Marshall in there, and Marshall says, well, we're going to do it. We'll beat it. So these are the areas in which the U.S. Supreme Court has authority. In all cases affecting ambassadors, other public ministers, or consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. That is, right away it goes to a federal court or the Supreme Court, not through appeals. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and to fact, with such exceptions and under such regulations as the Congress shall make. So in most of these other cases, the Supreme Court's going to be the final umpire, the final referee, but it's got to go through the court process. Now, this is very hard for many of us to take, especially conservatives more recently, with many of the court challenges in the cases. But here's what that comes down to, is an issue of rightness. That is, as I said before, the Supreme Court will not deal in hypotheticals. You cannot bring them a what-if case trying to test an idea and saying, well, what if we passed an abortion law that said that any abortion since the moment of birth is murder? The Supreme Court's not going to engage in that. The states have to pass the laws. Then it has to go through the appeal process, including the federal appeal process. And then and only then will the Supreme Court get involved. Now, we have seen recently that there were a number of gun cases beginning back around 2006 or so, with the Heller case in DC and the Broom case most recently here in New York City. And what has happened was that this was kicked upstairs, appeal by appeal, till it got to the Supreme Court. And the Supreme Court has been very consistent that firearms are a personal, not a collective right. And we'll get to that when we get to the Second Amendment and the militia cause. But basically, it says the individual has the right to own a firearm. And they've been fairly broad-minded about that individual right, even to the point that recently they have said that felons have the right to own a firearm if the felony is not a violent or firearm-related felony. And this had to do with a case of fraud. And basically they're saying, come on, fraud isn't the same as killing somebody or beating somebody up. It's not a violent crime. Fraudster having a gun is probably not the same as an ex-murderer having a gun, something like that. Or a murderer who was given freedom, something like that. Okay. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the crime shall have been committed, but when not committed within any state, the trial shall be at such a place or places where the Congress may by law be directed. Now, I think, you can correct me on this, I think that states have passed laws that have been assented to by the courts that say that the defendant may choose a trial by jury or trial by judge. You might want a trial by judge if it's a fairly complicated and intricate case that you're afraid will get lost on ordinary people. That involves a lot of legalities, but in the most cases, people are going to want a trial by jurors or a jury of their peers. Now, recently, this phrase, "what's a jury of my peers," has become quite an issue, especially in DC, where for some people, there are no juries of their peers. It's such a liberal city. It's so overrun with really far left people that it's hard for any conservative to get any fair trial in DC. Hence, all of these Patriot Day or J6 defendants getting slammed because there's just no conservatives in DC. It's a very, very liberal town. Almost all of the population there is in some way dependent on the government. So they're almost never going to rule against the government. You can see how this operated, though, in the trial of the 4 police officers out in California in the early 1990s who were accused of badly beating motorist Rodney King. And they were tried the first time up in Ventura County, which was at the time a very white and very suburban type county, and they were acquitted. And they were tried a second time on, as I recall, federal charges in LA, which is a very liberal county, and were not acquitted. So what's a jury of your peers? I'm a PhD. Is a jury of my peers PhDs? I'm white. Is a jury of my peers only white? I have a certain income level. Is a jury of my peers only a certain income level? I mean, you can see the issue here as to when does a jury randomly selected from an urban area no longer become a jury of your peers? And we've seen, for example, with the Alex Jones trial, that in most big urban areas now, whether it's New York, Austin, Atlanta, DC, Chicago, LA, even Phoenix, where I live, most of the urban areas now are extremely liberal, and a conservative, certainly a more radical, outspoken conservative like Alex Jones, is not going to get a fair trial with a jury of his peers in some place like that. So it's becoming quite an issue. And I look for it to be revisited fairly soon by the courts. Okay. Let's see. Section 3, treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. So I ask you, did Ted Kennedy, going to the Soviet Union, telling the Soviets that we were their pals, we wanted to help them, that President Reagan was nuts in trying to bring them to heel, was that giving aid and comfort to the Soviets? I would say absolutely. During the Iraq War, Senator John Kerry had conversations with the Iraqi resistance or the Al-Qaeda people. Was that giving aid and comfort? I would say yes. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have the power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. In other words, you can't go in and go after his family as they used to do in England or China. China was very big about if you were accused of treason, they not only would kill your whole extended family, they would kill everybody who worked with you, who interacted with you, who bought, sold clothes from, food from. I mean, it was vicious. Yeah, China. Article 4 states, Section 1, each state to honor all others. This is called comity. Full faith and credit shall be extended in each state to the public acts, records, and judicial proceedings of every other state, and Congress may, by its general laws, prescribe the manner in which such laws, records, and proceedings shall be proved and the effect thereof. Section 2, citizenship extradition. Citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. A person charged in any state with treason, felony, or other crime who shall flee from justice shall be found in another state, shall on demand of the executive authority from the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. So you go to another state hoping to get away with it, they're going to catch you and send you back. No person held to service or labor in one state under the laws thereof, escaping into another, in consequence of any law or regulation thereof, be discharged from such service or labor, but shall be delivered up on claim of party to whom such service or labor may be due. This is slavery. Again, they don't mention slavery and they talk about persons, people, which is very, very important. But this particular phrase is talking about runaway slaves. You run away from Kentucky into Ohio and you're captured in Ohio, they're going to send you back. Section 4, additional states. New states may be admitted to Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as of Congress. Oregon. There are a number of counties in Oregon seeking to leave crazy Oregon because it's such a lunatic asylum up there. And they're trying to merge with Idaho. For this to happen, the legislatures of Oregon and Idaho will have to go along with it, and the US Congress will have to go along with it. I don't see that happening. I don't see Oregon going along with it, and I don't see the Congress going along with it. Same thing with many of the Northern California counties that feel like they're trapped with all the liberal Southern counties. They're stuck, I think. Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Section 4, Republican government. The United States shall guarantee to every state in this union a Republican form of government, shall protect each of them against invasion, and on the application of the legislature or the executive when the legislature cannot be convened against domestic violence. I would say the border states have a case against the current administration, which is not protecting their borders from illegal criminal invasions, according to this. Article 5, amendments. Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states. So 2/3 can call a convention, but 3/4 have to ratify. Or by conventions and 3/4 thereof, or you can just have 3/4 of the states start their own process to amend the Constitution and change it that way. Or as the one or the other mode of ratification may be proposed by Congress. So you can do it either way. Provided that no amendment which may be made prior to the year 1808 shall in any manner affect the 1st and 4th clauses in the 9th section of the 1st article, and that no state without its consent shall be deprived equal suffrage in the Senate. So they're saying basically that rule on the slave trade has to stand until 1808. You can't get rid of that one. Now, we'll go into at the end of this. No, this is a good place to stop. So we come back to the Constitutional Convention. And if enough states ratify this, you can have a constitutional convention that can address, in theory, the issues or articles brought for the consideration of the delegates. And my warning to you is it will not be restricted to that. The first one wasn't. The first one, first thing they did, met in secret. Second thing they did, abolish the articles. So don't you think you're going to somehow control those delegates once they get to this CONCOM. I said this before, but I need to reiterate this. You can't control your state legislators. Can't control your state senators. They often vote ways you don't want them to vote. Can't control your governor. Can't control your U.S. House representative members. Can't control your U.S. senators. Can't control the president. Can't control your judges. How in the world are you going to control delegates to a con-con? You show me that you can control these other people first, and I might go along. And by the way, you can't. That's the whole reason you want to call it con-con, is because you can't control them. Even though you constitutionally right now have authority to control them, you can't or won't. But you want to have a con-con and think that magically you're going to get a whole bunch of Ted Cruz's and Donald Trump's and Newt Gingrich's and whoever you want to pick up there. And they're going to be wise and not exceed their mandates and something. No, you're going to get Mitt Romney's. You're going to get Chris Christie's. On our side, forget about who the left sends, because they will send nut jobs. I'm talking about our side. Right? You're going to get Lindsey Graham's. Now just think, do you really want Mitt Romney, Chris Christie, Lindsey Graham, people like that, taking a look at gun laws, taking a look at what rights you may have? Because you're very stupid to them, you understand that. You're just mind-bogglingly dumb. You can't understand this Constitution. They're going to tell you how to understand it. So beware. You heard it here first. I told you, right? Look at me. Look at me. I told you. All right, we're going to stop right there. We'll pick up next time with Article 6 on death, supremacy, and oaths of the U.S. Constitution. We only have a little bit to go in the Constitution, but we have the whole Bill of Rights to go. A lot of Bill of Rights amendments. So we will come up with those next time. And in the meantime, folks, you've probably been watching Sound of Freedom. If you haven't seen it yet, you're at least paying attention to it. This movie is now done, as of today, $85 million in business. That's outperforming Indiana Jones and the Colostomy Bag, or whatever that movie's called. That's outperforming most movies out there. And this movie has no international release yet, and is being shown in about half the theaters in America, not all of them. So what I'm saying is this movie is already making a magnificent, powerful impact. And if you've seen it, then you know what I'm talking about. So the time is here. The time is now. We need to turn Patriot's history into a feature film followed by a series of 1-hour videos. Help us do that. Go to the Wild World of History. Watch the incredible trailer, the concept trailer, and buy me a copy. Buy me 5, buy me 10. I'm having people buy me 3, 4, 500 copies. We need a lot of copies to make this. It's not an inexpensive process. Sound of Freedom was $15 million to make. So help me out. Go to the Wild World of History and buy Larry a coffee. And I'll see you guys back here on Wednesday.